The next case is Dr. ROOTER Supply and Service versus MCVAY. How much time would you like for rebuttal?
8 minutes, if you don't
8
mind.
minutes?
May it please the court? This case is Dr. ROOTER Service and Supply, Inc. and Thomas Wall v. Laura McVeigh, case number 5D14-3498. And this case, I'm sure you guys are aware, involves a plumbing business in Palatka. And in that business, it was owned by Mr. Wall and Mrs. McVeigh while they were married. It was started while they were married. They were a married couple. And during that time, their marriage ended up failing. They dissolved. Following the divorce, as part of the divorce proceedings, following the divorce, Mrs. McVeigh, who had previously been the office manager of the business, it was discovered that she had embezzled approximately $120,000 between the years 2007 and 2011, which was immediately before the divorce. That was discovered upon an internal review done after the divorce was finalized. Now, because of that,
there was an allegation in their brief, or an argument made in their brief, that in the initial complaint that was filed by your client on the civil theft claim indicated that the internal review was done at a time before the dissolution proceeding.
I believe that the initial complaint said that it was done sometime after early 2012, which is when she actually left. The court dismissed it with leave to amend so that I could put the actual date in that was discovered, not just the date she left. And so that's what I did in the amended complaint.
Okay.
Which was following that date.
Would you agree though that the business was a marital asset?
I have no argument that the ownership of the business was a marital asset, and I don't think that's what this case is. It was just the stock. We're talking about stock certificates here, right. And that's not what I'm talking about. I'm talking about. It turned out after she left, they discovered that about $120,000 in cash was stolen from the business over the span of 4 years by her, and so the business brought suit in order to recollect its assets. And regardless of some of the arguments, I mean, this case was in its infancy. I mean, it had basically, the pleadings had been closed for 2 months. The motion for summary judgment was filed contemporaneously with the answer. There was nothing done between the time the pleadings were closed and the motion for summary judgment. It came with the answer.
Well, there was a first complaint. There was a significant amount of time between the first complaint and then that was dismissed with leave to amend, correct?
Yes.
And then the filing of the amended complaint, and then the answer and the motion for summary judgment. So there was a significant period of time between the two. So during that time, was any discovery conducted at all?
No discovery was conducted during that time. I typically don't conduct discovery until after the pleadings are closed, so that I know what issues that I can direct discovery towards. I don't want to.
Was there any discovery served after the amended complaint?
There was no discovery served after the amended complaint.
Or after the notice of hearing for summary judgment?
No, there was no discovery served after the amended complaint or the notice of hearing of summary judgment, and there is a reason for that. The reason was because I had reviewed the motion for summary judgment and understood the misunderstanding that had occurred between the ownership and then the estate assets. And I knew that was something that it was not going to require discovery to resolve. Mr. Rowe, my opposing counsel, had gone through
If you didn't need any discovery for the motion, why does that matter that the motion went forward and was heard without discovery?
It doesn't matter. I would argue.
You raised that as an issue in your brief. I went ahead while discovery hadn't been completed. If you say you didn't need discovery for the hearing, what does it matter?
To the extent that discovery was necessary to combat I don't believe that discovery was necessary to combat the legal arguments. However, I didn't decide the case. So to the extent that discovery was necessary, then we didn't have enough time to fully complete it.
But you don't think it was necessary?
But I
You
don't
said
believe
you
it's
think it was
necessary.
And then why is it even an issue in your brief?
Overabundance of caution.
Over an abundance of caution. If you would like me to go ahead and withdraw that, I would be more than happy to.
I think it is a legal argument.
Honestly, I'm just trying. What I was trying to do is that was something that I brought up before the appellate or before the lower court, and I said, "Hey, look, Your Honor, we're at the beginning of this case. This isn't ready yet. You know, let's go ahead and it's a motion for summary judgment that was done."
If we all agree it's not that important, why don't you go ahead and focus
Let's
on what
move
you
on
think
to
is.
something else.
Okay. So here, I think that the main issue, the most important issue, is whether or not the assets inside the corporation were marital assets. And I think that the case law here, specifically the Anson case, which I cite extensively in my brief, demonstrates that they are not. Assets of a corporation is a separate legal entity, and it owns its assets in its own name. They are not marital assets. In fact, one of the cases cited by my opponent, the Beers case, it says in the footnote, a marriage is not a business arrangement and business partnerships are not governed by Chapter 61. That's in footnote 5 of opposing counsel's main case. There is a difference between a business relationship and a marital relationship. Now, that doesn't mean the marital partners can't own the company together. And in this case, they did. They didn't even own equal shares. It was a 20-80 split. But they still owned it together. But that doesn't mean that she has carte blanche to remove cash from the business. And so that's where I think, is this counting down or up? It's like another minute.
It counts down, and it'll turn yellow when you're into your rebuttal
Okay,
time.
great, thank you. This is the second oral argument I've done, so I apologize if I'm a little bit unfamiliar. But that's basically, I think that's where the main, and all of the judges' decisions below, holdings below, hinge upon whether or not this was a marital asset that was stolen or not. And here, I think it's clear, the corporation, it's extremely important, the corporation was not joined as a party to the divorce. This court on several occasions, and they're all listed in my brief, I've got a 3-case string cite that basically says, look, starting with the Keller case, look, if you don't join the marital corporation, then it's not a party to the divorce. And their whole argument is, no, you signed a general release, Mr. Wall, during the divorce proceedings, so therefore the company has no cause of action. And that simply isn't true.
Did the company sign the release? It did not, did it?
Did not.
Did anybody sign on behalf of the company?
It did not. Mr. Wall signed it. He was the only party. Not in his individual capacity as the husband. And I think one last point I would like to make before my time runs up here, which I noticed, I can't believe I missed this right before I did my reply brief. But in the answer brief, it says that her motion for summary judgment was supported by an affidavit. It was not supported by any affidavits. It was completely and utterly unverified. An affidavit was filed the night before the hearing on the motion to dismiss. I did not even receive a copy of it until I got to the hearing. That's reflected in the record. In fact, I didn't even receive a copy of it at the hearing. I was allowed to look at the original that they happened to have. So,
Did you object to that?
Yes, Your Honor, I did object to it. And so
And that was the only factual support?
that was the only factual support. Everything else was everything else was legal argument. So actually, I did miscalculate on the time. So the legal argument that it was not supported. The thing that's important about that is if you look at all the facts that were relied upon by the trial court, they're all these weird, unsupported, vitriolic allegations about how my client flew into a rage and was, burning down villages and doing all sorts of horrible, horrible things for basically filing a civil theft complaint. I filed a very neutral civil theft notice. I think when you review my complaint, you'll notice that it's neutrally drafted. I do have to accuse her of embezzlement because that's the civil theft. But this isn't an episode of Jerry Springer. This isn't high drama. This is, look, you took $150,000 $20,000 from a business. And the business wants it back and is allowed.
Let me ask you this, I'm looking at your initial complaint, and it says that an internal audit was conducted following her departure from the business in early 2012. And then it talks about a brief initial audit, and that all appears to be before the filing of the dissolution proceeding.
That was the initial complaint. That was after she left. She left in early 2012.
Okay, so that's not when...
That's not what the amended complaint says. The amended complaint gives the actual date. And there's been a lot made about my use of the term audit. That was a grammatical choice that I took. I was using what I thought the definition, which I still think the definition is, dictionary definition, a review of business records. This wasn't like an official, they took it to a CPA audit. This was, they went through their business records and provided me with a number. This is what happened. And I mean, I can, one of the arguments they have is that I didn't attach the audit to the complaint. Excuse me. This is the audit. These are all the business records from that time period. There was no summary sheet done. I was given this by my client. I said, go back and review your records.
Your client just reviewed his records, or did he have
His
to
office
send it out and
manag-
have an auditor?
His
do it?
office manager had his office manager review the records. His new office manager went through and reviewed all of their records, went through all the records, took the deposit slips versus the receipts that showed the cash receipts, so they would see here's where we took in cash, here's where it was not deposited, and then they provided me with just a simple number. Hey, look, this is the amount. So when they complained that they never asked for discovery either, and I pulled this out in front of the judge when they were arguing this. They didn't ask for any discovery either. Here, if they want the audit, here it is. I have it. Just ask me for it.
But in your amended complaint, did you assert that your client did not learn of the embezzlement or theft until after?
In the amended complaint, I listed the date in which this was done, and it was discovered that $120,000 had been
After the
stolen.
consent judgment?
After the consent judgment.
And that's the complaint that the judge was considering when summary judgment was entered?
Yes, Your Honor. And to the extent that even if Mr. Wall may have been aware, which I do not believe the facts are going to point out, but again, we don't have that in front of the record. There's been nothing sworn. But even in the event that he may have had some inkling that all was not right, the extent of it certainly was not known until well after the divorce was finalized. Because that's when they discovered it, and that's when they came to me.
So there was some knowledge of it prior to when the divorce was?
I don't know to the extent in which he had knowledge of it. I know that that he has gone through some discovery. I can't remember what his testimony was to that in the bankruptcy proceedings about when he knew what. And I would be remiss to tell you guys what it is without knowing it. I'm just saying I think that there may have been, and that would be something that for discovery, which we never got in this case. There's no facts in the record beyond it, but there may have been, he may have had some inkling that something wasn't right before she left. And then, but it was not fully discovered until after the divorce was finalized.
Well, if he did have an inkling that something wasn't right before she left, wouldn't it have been his obligation to raise that in terms of dissipation of assets in the divorce proceeding?
We're not talking about a dissipation of assets, however. We're talking about a theft. And I think that's where we keep getting, into, a big deal. It is a huge distinction because, and I'm actually a little bit over my time, but.
Well, you're into your rebuttal time. But
Yeah.
You can save it or you can
I'll
wait.
save it.
Okay.
May it please the Court, Your Honor, Counsel. Adam Rowe on behalf of the appellee, Laura McVeigh. I think we've had a fair discussion of the facts of this case with opposing counsel's presentation. This was a 36-year marriage. During this marriage, a business, Dr. Rooter Supply and Service, was built on the brow and the sweat and the work of both.
It was a corporation, correct?
It was a subchapter S corporation.
There were two stockholders.
Yes, sir. It was a
A wife and a husband.
small subchapter S corporation, closely held. There were two owners, the husband and the wife.
Okay.
There were never any other owners whatsoever at any point that's
What
germane to
difference does
this
that
appeal.
make? It's still a corporation, correct?
It is still a corporation.
The
However,
corporation's income and its subchapter S corporation taxes personal income, or is it taxes?
yes, in a subchapter S corporation, the tax of the corporation as far as the losses and whatnot pass through to the owners of the corporation, which in this case were the married couple.
That's just a tax code situation.
Right, that is just a tax code. But in this case, what has happened is there was after 35 years of marriage, there was a very sad and a very contentious divorce, which ended with my client waiving her right to alimony completely, and instead they structured this, and this is before I was on the case, as a equitable distribution of property. Ms. McVeigh assigned her interest in the Dr. Rooter Corporation to her husband, so her husband becomes the 100% owner. Prior to this, and that was after the divorce, okay. Prior to this assignment, my client was the other. Now, there is a disputed fact, but it is not a material fact. My client holds that she owned 50% and Mr. Wall owned 50%. I believe their position is that my client owned something like 30%. However, they were a married couple. Each one has a 50% equitable interest in the other's party at the time of the divorce, and so I think it's a fact that is disputed, but I don't think it's material because of the equitable marital interest that each other has in the spousal property and in the marital estate. This divorce was finalized. There was a release that was, and the language of the release is extremely important to this case, and I just want to put it on the record for the court.
Would you agree the corporation has a separate cause of action if someone steals money from it, correct?
For purposes of civil litigation, in the sense that a corporation is wholly owned by husband and wife,
Okay.
wholly owned,
Right.
and a cause of action, any cause of action between the husband and wife is released that could have been brought. The release language is very clear. Any claims which could have been resolved in this action, either party could have brought in the corporation that they owned together. Either party could have brought a shareholders derivative suit, but they did not. The release was any action that could have been brought, and that was not, it didn't happen. This action arises from the exact same factual nexus as the divorce action.
Well, the corporation itself had a claim. The only way you could release that claim would be if an officer in their representative capacity released it, correct?
No, Your Honor, if this was
So a shareholder, General Motors, could release General Motors?
this is not General Motors. General Motors is a large publicly traded
Doesn't matter.
corporation. I
Legally,
disagree.
it makes no difference if they're
Disagree,
small or
Your Honor.
large.
There's case law that I've cited in my brief that says, for purposes of equitable distribution, a closely held subchapter S corporation owned solely by husband and wife is a marital asset.
There's no
Thus-
question about that. I agree with that.
Thus,
But it's represented by the stock,
the stock,
not
stock is
the
just
assets of the
ownership.
corporation
The
are.
stock is just the ownership of all the assets and liabilities of the
Correct.
corporation,
Correct.
which was divided.
But a
equitably.
stockholder does not own the assets.
So
The corporation is a legal fiction. However, in this case, is a special case because there's only a husband and only a wife
So
that
if
own
a
the
truck owned
corporation.
by this corporation was in an accident, they could sue your client because she's a shareholder?
Well, they could if they attempted to pierce the corporate veil, or if my
Well,
client.
exactly. I mean, but they couldn't otherwise, correct?
Well, either of these parties to this divorce action could have joined the corporation and brought these claims.
They
They
didn't.
released each other from any claim that they could have brought.
They didn't bring it.
Right. And so it's res judicata, and that is what the lower court held.
I think the lower court made a mistake on that because it can't be. Because the corporation was never a party. How could it be raised judicata against the, it's not Mr. McVeigh bringing the claim, it's the corporation.
Well, actually, technically, Your Honor, the claim is brought on behalf of Mr. Wall, who is the former husband, and Dr. Rooter, which is
Mr.
the...
Wall.
Yes, sir.
But
But regardless, I think that's a minor point. What
Where
I'm
was the
saying-
issue litigated below as to her taking money? I mean, in fact, in the consent judgment that includes the release, paragraph 17 at 168 of the record, it says financial disclosure. Each party's made sufficient disclosure as to his or her income, assets, liabilities, and basically there is no other information requested or required. Each party warrants the disclosures made by him and her are true and accurate. Your client didn't disclose that she had taken, allegedly, $116,000, did she?
My client did not take $116,000.
Well, I'm saying allegedly. She didn't say, I took 116, therefore I've disclosed it.
No, sir, that's not what we're saying. And
Well,
my
if it
client-
turns out
my
she
client-
did take the 116, then she didn't disclose, and there's a fraud here, isn't there?
Your Honor, there was, the complaint alleges that this occurred prior to the release. All of this has been released. Mr. and Mrs. McVeigh released any claims, not just any claims that they had, but any claims that they could have
In the
brought.
amended complaint, which is what summary judgment was granted on, does it say that husband knew about this prior to the consent judgment?
I think that they changed the date by about 9 to 10 months in the amended complaint to avoid that problem.
Exactly, and but it's the amended complaint that you got summary judgment on,
Well, Your
correct?
Honor,
Yes or
amended
no?
complaint, you can plead alternative causes of action, but you can't plead alternative facts. I mean, there's still
There were no alternative facts pleaded. What they pled was this knowledge was gained after the consent judgment, yes or no? Isn't that what they claim?
that is what they claim. Yes, Your Honor.
All right,
Although
and
they,
then,
but
hang
they,
on, and then how can a judge look at that with summary judgment and say, no, you knew about it beforehand?
Because it was released. They had a duty, he had a duty, Mr. Wall had a duty.
How can you release something you don't know about when it's been hidden?
Because you've had ample opportunity to conduct discovery and to conduct all sorts
Well,
of
let me ask you
investigation
this.
in the final divorce case.
Let me ask you this. There's an argument by your client that he knew about this beforehand.
Correct.
They're claiming in their complaint, we didn't know about it till after the fact. Doesn't that create an issue of material fact that would preclude the entry of summary judgment?
No, ma'am, it does not, because the parties had ample opportunity in the divorce case to conduct discovery, and the parties released each other, not just from any claims that they had, but any claims that they could have brought. Each of them, at the time of the final judgment, was an owner, part owner of Dr. Rooter. Each of them could have, as a shareholder, brought suit, could have joined the corporation.
has the claim. The
But the corporation was
has the claim.
owned solely by the husband and wife in this area.
Doesn't matter.
I think that it does make a difference, Your Honor. I think there's a huge difference between a corporation that has many different owners or a publicly traded
In
subchapter
some ways,
C
yes, in some ways, no.
Your Honor, these folks had, what Mr. Wall is looking for here is a mulligan. He's looking for a do-over. He had his opportunity to do this investigation. He had his opportunity to find this. He did not. He settled. He did an equitable distribution settlement. My client remarried. Someone, I think, informed him that if he would have just done alimony, he would have been off the hook. I think that upset him, and I think that is
in the
the genesis
record?
of this case.
Is that in the record?
I'm not sure how much of that is played in the
Well, then
record.
let's not-
We're on summary judgment.
Let's not go into anything that's not in the record. We got enough here. And count.
I believe I have pled that. I mean, we're on summary judgment, and my client filed an affidavit verifying that all the factual.
When was that
allegations-
affidavit filed?
It was
That
filed the
seems-
day of the hearing on summary judgment.
And under what rule is that permitted?
I'm not sure what rule, Your Honor. However, there was no new information contained in the affidavit. It simply verified the factual allegations that had already been filed in the summary judgment motion.
Doesn't the rule specifically require that such affidavits be filed in advance of the hearing date?
I believe that it does, Your Honor. However, I believe we argued about this at the trial below, and the court found that since all the affidavit did was blanketly acknowledge the facts alleged in the summary judgment motion, which had been on the record for some time, that there was no prejudice, and allowed it. Your Honors, this is what Mr. Wall is looking for here is a do-over. He didn't like his final judgment of dissolution of marriage. After a year of abiding by it, he decided he wanted to redo it. The case law that I've cited clearly says that litigants to a divorce proceeding are entitled to a final distribution of their property, to a final winding up of their marriage at the time that their divorce ends. All my client is asking is that that final judgment of divorce be enforced. All claims that could have been brought were released. Both of these folks were shareholders of this corporation. Both of these folks could have brought the corporation in and brought that claim. Neither of them did. They released it. They were the only shareholders. And all of this second suit is just an attempted do-over. It's an attempted reset, and it shouldn't be permitted. It shouldn't be allowed for basis of public policy. People are entitled to have their divorces wound up at their final judgment of divorce. My client vehemently denies that she ever took any money inappropriately from anything, but that's not before this court. The question is the release effective or
Let's
not?
say for argument's sake, she did, all right? Was that considered an equitable distribution?
If she did take the property, then she dissipated the marital asset, and dissipation of marital asset can only be litigated under the divorce statute, which it was.
Was it litigated?
We have a final judgment of divorce. They went to a mediation.
Was that issue litigated?
I have no knowledge of whether it was how or I.
I think
They're
it
claiming that it was
must be
not, but I
very
wasn't the counsel on the divorce case until long after this all happened.
Well, if you
I
can't tell if it was litigated, how can it be res judicata?
It's res judicata because they signed a final divorce agreement, and because that was entered as a final decree of divorce, and because their divorce was finalized. And I think that my client and the people of the state of Florida have the right to have their marriage
So
end finally.
what's the remedy if, let's say for argument's sake, that, that the former husband discovered, exactly what they say, discovered after the fact that this money was taken. So what is the remedy for that, to go back to the divorce to family court and try to get a modification of the agreement? What's their remedy if there's a clear theft that they have been able to show? What, after the divorce, what is their remedy?
There's no dispute that the alleged theft, the theft that is alleged to have occurred in the years that these two folks were married.
Right, but
The
at the time of the discovery
Yes,
of
ma'am.
the
The
of
remedy for the husband was to use his powers of discovery to discover this theft and litigate it under the dissolution of marriage statute, because it is nothing more than an allegation, a bare allegation, that the wife dissipated a marital asset, which is the Dr. ROOTER company. His remedy was present in the divorce case. Once he signs a release, once the divorce is finalized, they say, anything we could have brought against each other, we're done, this is our deal. The case law says that my client is entitled to a final disposition of that property. And if the court goes in a different direction, what you're going to end up with is an even more never-ending family law litigation, and Lord knows we have enough never-ending family law litigation in this state. I would also just like to point out, I'm not sure where we stand on this issue of discovery, but to my knowledge, I don't think discovery was ever attempted or conducted. This case pended in the lower court for a little bit under 1 year. I don't think it was ever raised. He said it was raised, but maybe he is.
I don't think it's an issue
Okay.
for us.
If it's been withdrawn, then I won't address it. I'll be happy to answer any further questions. If not, I'll give up the rest.
Thank you. Any questions?
No, thanks.
Thank you, Your Honors.
You have right at 6 minutes left.
That's fine. I am not aware of any argument that was done below regarding this affidavit. It was never resolved. I don't believe it's relied upon in the order. If my recollection of what the order language is, it was not cited in the order. I certainly objected to it at trial. There was never a ruling, to my knowledge, that it was determined that it was not prejudicial because it it was filed, well, not prejudicial because it was just verifying the complaint. In fact, and again, I don't have the record number. It is, I believe it is in the record. It is the motion for summary judgment transcripts on the top of page 4 is where I object. Your Honor, I'm going to object to using that, speaking about the affidavit. I have to have 20 days notice before/on affidavits. And then then Mr. Rowe's response is, well, this case can be resolved strictly on legal arguments. There is no, but Judge, it doesn't prejudice Mr. Davey. In fact, it does quite vehemently prejudice me. During my argument, I said, look, all of this is unverified allegations, and they're all extremely vitriolic and extremely dramatic. I've been 57-105 on this case twice. I got 57-105 on this case when I filed my civil theft notice. And because, if you know, you have 30 days for the civil theft notice. You have 21 days for the safe harbor provision. Regardless of the fact that there wasn't a pleading filed that was offensive that I could remove, it was just a notice, they understood that if they had to have me as a party if I was going to be sanctioned, so they tried to implead me into the family law case. They understand that you have to plead somebody into the case to get jurisdiction over them. They didn't do that with the corporation for whatever reason. But for me personally, to try to cite me for just sending off a very neutral blanket civil theft notice, they tried to implead me into the case. So to say that they weren't aware that they had to implead or that they thought it was good enough, that's not true. That's just not the case. So at this stage, I think that the main issue before the court is whether or not Mrs. McVeigh, or whether or not the corporate assets are marital assets. And I think the case law is clear that the corporate assets are not marital assets. And one of the things the court has not recognized in its questions, but I think you're getting there, is what about the creditors? You've noticed this case has gone through bankruptcy. They argue that it went through bankruptcy as a delaying tactic. I would argue it went through bankruptcy because $120,000 were embezzled from the company and it couldn't pay its creditors. There are other people interested in those assets before they get dispersed through a dividend to the shareholders. That money has to be available for the business to pay its bills, to meet its obligations, to pay its liabilities. And to say that just because a shareholder signed off on the divorce, that any claims that the two parties may have against each other could have been released, that could have been brought. They weren't a party. This wasn't even a party to the action, the corporation. It is a separate legal entity.
Wouldn't one of them have to bring the other corporation in?
Yeah, they were more than able.
It can't do it itself.
It can't. Well, I guess it could. It could show up and intervene if it really, really wanted to.
Well, who's going to intervene on its behalf when there are only two people there?
Well, I'm just saying. The corporation could have intervened. The corporation's a separate legal entity, and I know in fact there is two people that are the owners.
But who would have done the intervening? It would have to have been either the husband or the wife bringing in the corporation.
Or they could have impled it, which is, again, they had the ability
husband or wife.
The husband or wife. The husband and wife could have impled it.
So, it's not like, this isn't a public corporation like General Motors where you have like 1 million people that are potential owners. You have the two people that signed this marital settlement agreement to release all claims that had the power to bring in the corporation. So I think that's what your opposing counsel is arguing, is that, there was no one else to bring in the corporation other than the two that were signing the agreement.
And she could have brought it in. If she wanted a release from the liability of this claim, she should have brought it in. And then therefore it would have been bound by it.
If the husband released his claims for other suits, even if you prove that the corporation had money taken by the wife, where does that leave him? Isn't he subject to being summary judgmented out, which then leaves the corporation only?
Potentially, he does have the summary judgment out. I think that I've got some arguments against that, based upon the language in the waiver itself, which is why I think Mr. Rowe went back over that language. But some arguments in that, and then of course and whether or not she was hiding whether or not she was hiding the fraud. And if she was hiding the fraud, then there is surprisingly little case law on whether or not if you get a release in order to continue a fraudulent endeavor, whether or not that release is good, because there's so much law about how general releases are to be liberally construed, and then there's some law that says, well, if you're being fraudulent in order to obtain the release, then maybe, but we're not going to rule it. It's always been ruled about for another reason in the court. The Supreme Court, anyway, has said we don't have to mess with this sticky issue. One of those rulings. But I would continue to argue, look, if there's fraud involved, then yeah, the waiver, the release wouldn't even be valid. Depending on the facts of the case, which we need to go to a factual question. This is all a question of fact. It all goes back down so that we can have our trial and resolve those questions of fact. So I thank you for your time. I apologize for going over.